The Senate will come to order. Will the clerk please call the roll?
Senators Baisley, Bridges, Buckner, Coleman, Cutter, Danielson, Exum, Fields, Gardner, Janal, Gonzalez, Hanson, Henriksen, Hawkes Lewis, Kirkmeyer, Kolker, Liston, Lundin, Marchman, Michelson Janae, Mullica, Pelton B, Pelton R, Priola, Rich, Roberts, Rodriguez, Simpson, Smallwood, Sullivan, Van Winkle, Will, Winter, Senzinger. Mr. President.
Here. The morning roll call is, perhaps for the first time this year, 35 present, 0 absent, 0 excused. Well done. We do have a quorum. Senator Rich, would you please lead us in the pledge?
Please stand with me if you can and join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Approval of the journal. Senator Roberts.
Thank you, Mr. President. I move that the Senate Journal of March 7th, 2024 be approved as corrected by the Secretary.
You have heard the motion. All those in favor say aye.
Aye.
Opposed, no? No. The ayes just barely have it, and that motion is adopted. Senate Services.
March 8th, 2024, correctly printed Senate Bill 176, 177, 178, and 179, correctly engrossed Senate Bill 68, Senate Joint Memorial 1, correctly re-revised House Bill 1067.
Committee reports.
March 7, 2024, Committee on Local Government and Housing. After consideration on the merits, the committee recommends the following: House Bill 1098 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation. March 7, 2024, Committee on Business, Labor, and Technology. After consideration on the merits, the committee recommends the following: House Bill 1139 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation, and with recommendation to be placed on the consent calendar. And House Bill 1060 be referred to the Committee of the Whole with favorable recommendation, and with recommendation to be placed on the consent calendar. March 7, 2024, Committee on Health and Human Services. After consideration on the merits, the committee recommends the following: Senate Bill 77 be postponed indefinitely. House Bill 1086 be referred to the Committee of the Whole with favorable recommendation, and with a recommendation that it be placed on the consent calendar. Senate Bill 142 be amended as follows, and is so amended be referred to the Committee on Appropriations with favorable recommendation. March 7, 2024, Committee on Agriculture and Natural Resources. After consideration on the merits, the committee recommends the following: House Bill 1155 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation, and with a recommendation to be placed on the consent calendar. Senate Bill 152 be referred favorably to the Committee on Finance. Member of the Coal Mine Board of Examiners for a term beginning July 2nd, 2023 and expiring July 1, 2027, Hugh Vince Cowan of Paonia, Colorado, to serve as a coal mine owner, operator, manager, or other mine official actively engaged in underground mining appointed. Members of the Board of the Great Outdoors Colorado Trust Fund for terms expiring April 15, 2027, Letitia Martinez of Denver, Colorado, to serve as a representative of the 1st Congressional District reappointed. John Montepari of Breckenridge, Colorado, to serve as a representative of the 2nd Congressional District reappointed. Pamela Denai of La Junta, Colorado, to serve as a representative of the 3rd Congressional District reappointed. Mina Liebert of Colorado Springs, Colorado, to serve as a representative of the 5th Congressional District reappointed. Morris J. Siegel of Boulder, Colorado, to serve as a representative of the 2nd Congressional District reappointed. Jahi Sinbai of Wheat Ridge, Colorado, to serve as a representative of the 7th Congressional District, reappointed. Members of the Colorado State Fair Authority Board of Commissioners for terms expiring November 1, 2027. Deb Suniga of Greeley, Colorado, to serve as a representative of the 2nd Agriculture District and as a Democrat, reappointed. Darius Allen of Alamosa, Colorado, to serve as a representative of the 3rd Agricultural District, Agriculture, and as a Republican, reappointed. Colleen Hale of Montrose, Colorado, to serve as a representative of the 4th Agriculture District as an unaffiliated, appointed. Members of the State Board of Stock Inspection Commissioners for terms expiring May 1, 2027. Natalie Rogers of Yuma, Colorado, to serve as a representative of the confinement cattle industry, appointed. Stephen Wooten of Kim, Colorado, to serve as a representative of the non-confinement cattle industry, appointed. Member of the Colorado Conservation Board, effective February 13, 2024, for terms expiring February 12, 2027. Brad Wind of Loveland, Colorado, to serve as a representative of the South Platte Basin, appointed. John McLeod of Gunnison, Colorado, to serve as a representative of the Gunnison Uncompahgre Basin, appointed. Barbara Vasquez of Cowdery, Colorado, to serve as a representative of the North Platte Basin, reappointed. Members of the Colorado Resources and Power Development Authority for terms expiring October 1, 2027. Stephen Eric Vandeveer of Alamosa, Colorado, to serve as a representative from the Rio Grande Drainage Basin and as a representative with experience in the engineering aspects of water projects, reappointed. Michael Fabre of Crested Butte, Colorado, to serve as a representative from the Gunnison Uncompahgre Drainage Basin and as a representative with experience in water project financing, reappointed. Matthew Schuler of Walden, Colorado, to serve as a representative from the North Platte Drainage Basin, appointed. March 7, 2024, the Committee on State, Veterans, and Military Affairs has had under consideration, has had a hearing on the following appointments and recommends that the appointments be placed on the consent calendar and confirmed. Members of the State Personnel Board, effective July 1, 2023, for terms expiring June 30, 2026. Kimberly Dempster of Denver, Colorado, reappointed. F. Robert Lee of Littleton, Colorado, reappointed. Members of the Colorado Channel Authority Board of Directors for terms expiring October 6, 2027. Bart Miller of Centennial, Colorado, to serve as a representative who has experience in the business operations, broadcast journalism, reappointed. Megan Jurgenmeyer of Denver, Colorado, to serve as a representative who has experience in the business operations of broadcast journalism, reappointed. Jessica Bralish of Arvada, Colorado, appointed.
Message from the House.
March 7, 2024, Mr. President, the House has adopted and returns herewith Senate Joint Resolution 13. The House has passed on third reading and transmitted to the Reviser of Statutes House Bills 1267 and 1309 and amended as printed in House Journal March 6, 2024.
Message from the Reviser.
March 7, 2024, we herewith transmit without comment as amended House Bills 1267 and 1309.
Mr. Majority Leader.
Thank you, Mr. President. I move that the Senate proceed out of order for motions of personal privilege.
You have heard the motion, perhaps. All those in favor say aye. Aye. Opposed, no? The ayes have it. The Senate will now proceed out of order for moments of personal privilege. Senator Kolker.
Thank you, Mr. President. Members, today we have some special guests. We have a tribute to one of the founding mothers.
Senator Kolker, just one moment, please. Members, let's pay our respect to the members in the well for their moment of personal privilege. Please proceed, Senator Kolker.
Thank you, Mr. President. We have a family members from one of the founders, the founding mothers of the city of Centennial. Kathy Noon passed away last year. She was the second mayor of Centennial, and I have a tribute to read. But I just want to acknowledge her husband, daughter, and granddaughters that are here today to pay respect to Kathy. The tribute states, the Senate and House of Representatives convened in the 74th General Assembly hereby mourns the loss of Kathy Noon. Kathy Noon was a visionary leader who served 2 terms as the city of Centennial's second mayor. She passed away December 11, 2023, after bravely facing pancreatic cancer for 5.5 years. She was a driving force behind Centennial's emergence and became an influential figure in her community. She served as the chair of the Centennial Homeroom Charter Commission, led a 21-member group in crafting the city's charter, and inspired transformative initiatives throughout the city. In 2019, the Denver Regional Council of Governments presented Mayor Noon with their highest honor, the John V. Christensen Award, recognizing her outstanding leadership and commitment to regional collaboration. The Colorado House of Representatives mourns the loss of a remarkable leader whose dedication and contributions left an indelible mark on the city of Centennial and its residents. On request of the Representatives Eliza Hamrick, Chad Clifford, and David Ortiz, and Senators Chris Colker and Tom Sullivan, given this 8th day of March, 2024, State Capitol, Denver, Colorado. Thank you, members. I just want to say, on a personal note, I've lived in the city of Centennial since its founding, and I always thought Mayor Noon was our first mayor because she played such a big impact, because of the work she did on the commission, because of the work she did establishing Centennial. And driving by on Arapahoe after, when she was mayor, they would have a sign up, come, noon with Noon. Speak with your mayor. She was always very open and receiving to the citizens of Centennial, and it's definitely a model that I'd like to emulate. So thank you very much.
Senator Zenzinger.
Thank you, Mr. President. Members, I had the good fortune of serving with Mayor Noon on DRCOG, and you heard about the award that she received from DRCOG for her regional approach. And she was quite literally one of the mentors that shaped my spirit of collaboration and bipartisanship. She was on the executive committee of DRCOG when I served on the executive committee, and she was such a graceful leader. When Kathy spoke, people stopped and listened. And that's because she didn't speak just to hear herself speak. When she spoke, it was with purpose, and she did just a tremendous job of clarifying what the issues were that were before us and getting rid of the fluff. She was a graceful person, she was a kind person, and I will miss my mentor very much.
Senator Bridges.
Thank you, Mr. President. For her role in creating the city of Centennial, I am just extraordinarily grateful because I grew up in Fox Ridge, which was Arapahoe County, Littleton Public Schools, Castlewood Fire, Denver Water, Englewood mailing address, and Arapahoe Sheriff. So just a complete mishmash of different competing districts. And Centennial finally brought that part of my home, that part of where I grew up, into some kind of meaningful relationship with those various different entities, those state government entities, and just for the pure simplification that it created. And also the way that it stopped other municipalities from coming in, annexing shopping centers and taking all the tax revenue. Much appreciation for that too. Centennial is a tremendous addition to our state, and so grateful that it exists and for the role that the person we're honoring today played in that. Thanks.
Senator Zenzinger.
I would like to just welcome the family that is here today. Thank you very much for joining us. And I would ask for a moment of silence and that the chimes be rung.
The Senate will stand in a moment of silence and the chimes will ring. Thank you, members. Senator Smallwood.
Thank you, Mr. President. I request a moment of personal privilege.
Granted.
Thank you very much, colleagues. On a much lighter note, I do want to welcome a guest who was able to join us today. Brigadier General David Gross is with us, retired from the U.S. Army after 31 years of active duty service, a few of General Gross's accomplishments at Fort Riley, Kansas. He was in the 1st Infantry Division as a battalion commander, and of 337 Armor during Desert Storm. Was the division chief of staff for the 1st Infantry Division in Fort Riley, Kansas, the commander of the Presidio in Monterey, California, and in Korea as the executive officer to the CINC, Fort Riley, Kansas, right outside my hometown, as assistant division commander for maneuvers for the 1st Infantry Division as well. I refer to him as Uncle Dave, but I would ask that we could please welcome Brigadier General Gross to the chamber.
Senator Hawkins Lewis.
Thank you, Mr. President. I am requesting a moment of personal privilege.
Granted.
Colleagues, come join us if you wish. Today is International Women's Day. Today, International Women's Day, is a global celebration that recognizes the invaluable contributions of women throughout history and the ongoing struggle for gender equality. This day holds profound significance as it is not only celebrating the achievements of women in various fields, but it also serves as a poignant reminder of the challenges that still persist.
Senator Cutter.
May I have a moment of personal privilege?
Granted.
Thank you, Mr. President. International Women's Day gained global recognition in 1977 when the United Nations officially marked March 8th as a time to reflect on the progress made and challenges ahead. The United Nations theme for International Women's Day 2024 is Invest in Women, Accelerate Progress. Over the years, it has evolved into a platform for highlighting the achievements of women and promoting gender equality. It is a day to acknowledge the remarkable women who have shaped our past, appreciate the contributions of those among us today, and inspire future generations to continue the fight for a world where women's rights are human rights.
Senator Kirkmeyer.
Thank you, Mr. President. And thank you to my colleagues that are represented here on the floor this year. I greatly appreciate that we are doing this together. Thank you so much. As we celebrate women this month, let us commit ourselves to fostering an environment where every woman can thrive, unleashing the full potential of our world for the benefit of all. From early 20th century suffragette movements demanding voter rights to modern-day advocacy for equal pay and opportunities, women around the world have shown resilience and courage in the face of adversity. International Women's Day is a call to action, urging us to address disparities, empower women, and create a more inclusive and equitable world for all.
Third reading of bills. Final passage. Will the clerk please read the title to Senate Bill 68?
Senate Bill 68 by Senator Janal and Representative Brown concerning end-of-life options for an individual with a terminal illness.
Senator Janal.
Thank you, Mr. President. I move Senate Bill 68 and ask for an aye vote on third reading.
Is there any discussion? Seeing none, the motion is the passage of Senate Bill 68. Are there any no votes? Senators Van Winkle, Priola, Baisley, Gardner, Minority Leader Lundin. Smallwood. Exum. Pelton B. Pelton R. Simpson. Kirkmeyer. With a vote of 24 ayes, 11 noes, 0 absent, 0 excused, Senate Bill 68 is passed. Co-sponsors, Senators Marchman, Hinrichsen, Cutter, Michelson Janae, Jaquez Lewis, Hanson. Please add the president. General orders. Second reading of bills, consent calendar. Senator Coleman.
Thank you, Mr. President. I move the Senate resolve in subcommittee of the whole for consideration general order second reading bills consent calendar. Was that good?
You have heard the motion. All those in favor say aye. Opposed, no. The motion is adopted. The Senate will resolve itself in the committee of the whole for the consideration of the general order, second reading of bills consent calendar, and Senator Coleman will take the chair.
The committee will come to order and the court rule is relaxed for everybody up in here. Will the clerk please read the title of the bill on the general order second reading of bills consent calendar?
House Bill 1119 by Representatives Morrow and Taggart and Senator Smallwood concerning the use of multi-state filing systems for insurance tax filings.
Majority Leader Rodriguez.
Thank you, Mr. Chair. I move the passage of the bill on second reading of bills consent calendar, which includes House Bill 1119, and there are no committee reports.
Any discussion on the bill on the consent calendar? Seeing none, a motion for the body's adoption of the bill on the general order second reading of bills consent calendar. All those in favor say aye.
Aye.
Opposed, no. The ayes have it, and the bill is adopted. Majority Leader Rodriguez.
Thank you, Mr. Chair. I move the committee rise and report.
Motion for the committee to rise and report. All those in favor say aye. Opposed, no. The ayes have it. The motion is adopted. The committee will rise and report. Yes, sir.
The Senate will come to order. Senator Coleman.
Thank you, Mr. President. The committee has had a bill in consideration. Will the clerk please read the report?
March 8, 2024. Mr. President, your committee of the whole begs leave to report as had under consideration the following attached bills being the second reading thereof and makes the following recommendations thereon. House Bill 1119 passed on second reading and ordered revised and placed on the calendar for third reading and final passage.
Senator Coleman.
Thank you, Mr. President. I move the report.
The motion is the adoption of the committee of the whole report. Are there any no votes? With a vote of 35 ayes, 0 noes, 0 absent, 0 excused, committee of the whole report is adopted. House Bill 1119 passed on second reading and order revised and placed on the calendar for third reading and final passage. General orders, second reading of bills. Senator Coleman.
Thank you, Mr. President. I move the Senate resolve in subcommittee of the whole for consideration general order second reading of the bills.
You have heard the motion. All those in favor say aye. Opposed, no. The ayes have it, and the motion is adopted. The Senate will resolve itself in the committee of the whole for the consideration of the general order, second reading of bills. Senator Coleman will take the chair.
The committee will come to order and the court rules relaxed again for everybody up in here. Will the clerk please read the title to SCR 24001?
SCR 1 by Senators Danielson and Fields and Representatives Duran and Weissman, submitting to the registered electors of the state of Colorado an amendment to the Colorado Constitution concerning allowing Colorado lawmakers to pass laws that permit victims of childhood sexual abuse to bring a civil claim for the sexual abuse regardless of when the sexual abuse occurred.
Mr. Majority Leader.
Thank you, Mr. Chair. I move to lay over SCR 001 till Tuesday, March the 12th.
The motion is to lay over SCR 24001 to Tuesday, March the 12th. All those in favor say aye. Opposed, no. The ayes have it, and SCR 24001 will be laid over until Tuesday, March the 12th. Clerk, please read the title of Senate Bill 94.
Senate Bill 94 by Senators Gonzalez and Exum and Representatives Lindsay and Froelich concerning safe housing for residential tenants and in connection therewith establishing and clarifying procedures regarding a tenant's claim of breach of the warranty of habitability.
Senator Gonzalez.
Thank you, Mr. Chair. We move Senate Bill 94 along with the Housing Committee report.
To the Local Government and Housing Committee report, Senator Gonzalez.
Thank you, Mr. Chair. Colleagues, in our committee, we heard incredibly compelling testimony, and as a result of ongoing and continuing stakeholder feedback, ran L001 to the bill that was reflective of discussions with the Children's Hospital, Colorado Cross Disability Coalition, Disability Law Colorado, the Energy Outreach Colorado, Colorado Affordable Legal Services, East Colfax Collaborative, the Denver Foundation, Colorado Poverty Law Project, and the Community Economic Defense Project. And we also, in L001, ensured and put forward language that was reflective of ongoing stakeholder work with folks who had concerns of the bill. And you see that reflected in the committee report, and I ask for an aye vote.
The motion is the adoption of the Local Government and Housing Committee report. All in favor say aye.
Aye.
Opposed, no. The ayes have it. Local Government and Housing Committee report is adopted. To the bill, Senator
Do you want to go first? Sure.
Exum.
Thank you, Mr. Chair. And I want to thank my co-prime, Senator Gonzalez, for allowing me to join her on this bill to clarify some things regarding making sure people have a clean, safe place to live. I want to go over just a few things that I went over in committee. Then I'll pass the baton back to my co-prime. In 2008, Colorado established a warranty of habitability standard in state statute, becoming one of the last states in the country to do so. The law was updated in 2019 through House Bill 191170 to establish certain conditions for when the landlord is not meeting the warranty requirements, processes for tenant to notify a landlord of issues impacting habitability, and timeframes for the landlord to begin remediation. Additionally, the law has currently created a large loophole that does not provide timeframes for landlords to complete repairs resulting in issues remaining for weeks and even months. The bill before you today, Senate Bill 94, as introduced, will bring some needed fixes and updates to existing law to ensure it works properly. The bill ensures that notice of health and safety issues can be given to landlord in various forms, including in writing, verbal communications, and thorough observation, and that the landlord is responsible for taking appropriate action when the notice is given. And we'll have an amendment to clarify that further. The bill also clarifies existing law, which requires that the landlord provide a hotel or comparable dwelling when the conditions interfere with life, health, and safety to the tenant. Specifically, the bill would extend this policy to include people with disability when an elevator maintenance makes a resident inaccessible. And finally, the bill also clarifies the process a tenant may pursue if the landlord fails to comply with the minimum requirements established in the law. Specifically, the bill would clarify the current process by which the tenant may withhold rent, pursue a court order demanding compliance with the law, or otherwise seek monetary damages. And we had a robust conversation in committee, and my co-prime explained the amendment that we brought in committee, and we'll have another amendment today to further clarify that. And I'll pass it over to my co-prime. Thank you, Mr. Chair.
Senator Gonzalez.
Thank you, Mr. Chair. Colleagues, I want to have a little bit of context here before we get into the bill language itself. I want to talk about why we bring forward this bill for your consideration and why we're going to ask for an aye vote. Back in 2019, the good senator from Greenwood Village brought forward legislation that was intended to protect tenants' life, health, and safety, and to also ensure clarity in the statute. for how complaints should be raised and how landlords should address those complaints. We're here today because in 2023, July 20th of 2023, just after our legislative session completed, we saw a Court of Appeals case, Anderson versus Shorter Arms. And the Division of the Court of Appeals decided as a matter of first impression, meaning this is the first time that the court had taken up this statute, and said that, I'm sorry, but these notice provisions are unclear. The court decided in that decision 2-1. And even in the dissent, between folks who interpret law for a living, in their dissent, the judge noted, reasonable minds can differ on precisely what type of written notice is required under Section 38-12-503. And in the dissent, the judge invited and reminded us here in this body, in this General Assembly, that we have the authority to amend the statute should we desire to clarify the exact parameters of the notice requirement. That's why we're here today, y'all. We heard from the plaintiff in the case, Mr. Alan Anderson, a man who lives with disabilities, who lives in subsidized housing, who's been a tenant since 2016. Over the course of years, he made written demands, oral demands. He even went to CDPHE and asked, begged his landlord over the course of years that his landlord repair numerous living conditions in his apartment that he considered to be deplorable. And I think y'all might too, including flooding with sewage backups, an unrepaired ceiling collapse from 3 years earlier. 3 years earlier. A malfunctioning heater, a malfunctioning stove, falling ceiling lights, a broken shower rod, a cracked entry door, poor ceilings around windows, a gap around the window air conditioner unit, a malfunctioning security door, and mold. He went and followed the exact terms of his lease that said, please come and provide and talk to us and provide notice. He followed what his lease asked him to do. Nothing got resolved. He wrote a letter saying, please address these issues. Court of Appeals found that because he didn't also say, and here's the times in which I am going to allow you all entry, apparently that wasn't specific notice either. He called CDPHE to try and ask them to ascertain, are there actually mold issues in my unit? Glad to hear it. And CDPHE, when they provided notice to Shorter Arms of possible mold contamination, again, nothing changed. Yo, what does a person have to do? That's why we bring this bill forward for your consideration. In testimony, not only did we hear from Mr. Anderson himself, who walked here in order to beg us to act, we also heard stories from landlords, from tenants, who say, Y'all, please. The vast majority of landlords, the vast majority of tenants do right because I believe Coloradans are fundamentally good people. But yet, apparently, the Court of Appeals said even though he followed the terms of his lease and provided verbal notice, because he followed after he didn't get a response and provided written notice via letter, and then invited a third party to come and conduct an inspection, somehow Mr. Anderson had not provided proper notice. It's why we bring forward this law, or this bill now for your consideration today. I could go on and talk about all of the devastating stories that we've heard. We heard from doctors who warned us about what devastating health impacts people can suffer with ongoing and unresolved mold contamination. And lest you all think that we're only talking about folks who live in rundown, falling apart buildings, we also heard from folks who live in real nice luxury apartments who still could not get their issues addressed. Y'all, this has happened in my Senate district. You hear me come up to this well often to talk about the ways in which my neighborhood has been transformed with development. This summer, a month after the Court of Appeals decision, 1515 flats, mixed-use development, small business at the bottom, apartments up top. Power went out across the entire building. Could not get their issues resolved. Tenants organized amongst themselves to try to get an attorney to take their case, and because of this Court of Appeals decision, could not get resolution. Now, it's one thing for us to just go forward and say, all right, well then let's just clarify the notice provisions and call it good. But I also think that it's important for us to acknowledge and recognize that there are additional pieces that we ought to address here within this legislation. Colleagues, I heard from tenants who not only were they dealing with raw sewage issues and mold issues, they also had a broken elevator that went unresolved for months. Weeks at first, and then months at a time. Despite being a building with multiple people who were disabled and wheelchair reliant, or who had significant mobility issues, one person missing a leg, one in a wheelchair, two in a walker. Disabled folks had no communication back from their landlords and were having to get multiple neighbors or family members to carry them down the only flight of stairs. One resident broke her foot in the fall in the stairwell. Given that experience, we are honored to partner alongside disability law CCDC, and others in order to update requirements around elevator repair. Because I just think that that is both safety, health, and well-being. Colleagues, we had a really powerful hearing. And coming out of that hearing, we didn't stop our work. We continued negotiations and want to, at this time, acknowledge a hefty amendment, L010, which I move at this time.
There is an amendment at the desk. Will the clerk please read L010 to Senate Bill 94?
L010,
Senator
amendment to
Gonzalez.
bill.
Thank you, Mr. Chair. I move L10 to Senate Bill 94.
To the amendment.
Thank you, Mr. Chair. L10 is substantive. It is a 6-page amendment. This amendment reflects the stakeholding and feedback from a variety of groups, multiple folks who raised concerns through our hearing and even after our hearing. This includes the realtors, the Legislative Landlord Coalition, and other housing providers, otherwise known as landlords, in order to address the concerns raised in the committee hearing. What L10 does is, look, we heard lots of concerns around verbal notice, but we also know and recognize that sometimes landlords and tenants come to agreements where they say, here's what we want to do. And so, given that, we preserve the requirement in current law that notice of an uninhabitable condition be provided in writing unless the landlord and the tenant have agreed on another means for providing notice. If they say, I want you to call me and I want to have a face-to-face conversation, this bill would allow them to, on a predetermined basis, before any issue arises, do that. Or if they say, hey, I want you to text me, this would allow them to do that. Otherwise, this amendment would shift that notice requirement to a written requirement. This amendment also requires that a landlord include contact information for reporting a condition in bolded font on a lease. And if there's an online portal, that it be bolded as well. L10 also eliminates the proposed new section that would have allowed a tenant to withhold rent. This is a big one, and I do not want it to be just swept under the rug. With this change, tenants would only be allowed to withhold rent as the law currently allows when they're deducting a portion to hire a professional who would make a necessary repair. L10 also caps the duration that a landlord is responsible for providing a hotel or a comparable dwelling unit, not to exceed 60 days, at which point the tenant may terminate their lease. Right now, there's no cap in current law. So this provides landlords with clarity and certainty for longer-term repairs. And that was a lot of what we heard concern about in committee. We heard concerns from landlords about how and when to enter property. And so L10 also allows landlords to enter property without giving prior notice when there's an active condition that would cause material property damage without immediate remediation. You got a water leak? I'm sorry, we're not going to schedule a time L10 addresses that. It adds back into law that a tenant may be liable for paying double the amount of rent that is wrongfully withheld if a tenant purposely does so in bad faith. Actions have consequences. L10 clarifies that a landlord is responsible for ensuring that trash collection is scheduled at appropriate intervals, clarifies that a landlord's not responsible for a lapse in water that's caused for reasons outside of their reasonable control, clarifies that a landlord does not need to provide information on community cooling spaces if none exists within 10 miles, increases a time frame for a landlord to provide requested documents from 7 to 10 days, clarifies that maintenance service does not include one-time or specialized third-party contractors who are not agents of the landlords, and only provides a limited or expert service to the residential premises so that tenants can only report conditions to the landlord. There's a couple of other technical conforming amendments to ensure that there is no contradictions, but colleagues, I wanted to take the time to explain to you L10 because I know that it's meaty, but I hope that you all recognize that this is work that is done as a result of ongoing and continued negotiations. I ask for an aye vote on L10.
Seeing no further discussion on L10, is your discussion on L10? Senator Gardner.
Thank you, Mr. Chair. Well, I appreciate the amendment. It seems to take care of one of the concerns I had concerning the use of the term constructive notice and what constitutes actual notice, constructive notice. You need to understand constructive notice. People say, well, what does that mean? Particularly when you have constructive notice in a construction contract, which have nothing to do with each other. And it is a concern I have in the bill that the amendment does seem to address, that you're deemed, in a lot of cases, let me explain the term constructive notice. Sometimes the law lets people print something in the newspaper, a newspaper of general circulation, and that will constitute constructive notice to the world of something, and that's defined. That's a concern here that I think this amendment does deal with. On page 3 of the amendment, starting at line 19, really substantively starting at line 22, it says, on or after January 1, 2025, every rental agreement between a landlord and tenant must include a statement in English and Spanish and in at least 12-point boldface type that states an address where a tenant can mail or personally deliver written notice of an uninhabitable condition and an email address or accessible online tenant portal or a platform where a tenant can deliver written notice of an uninhabitable condition, and on. This amendment, and when you talk about an amendment, it sometimes drives you back into discussion of how it operates with the bill. This amendment, on its face, for many, many landlords is kind of innocuous. Innocuous in that if you have a standard lease and you're a major corporate apartment holder, landlord in the state of Colorado, you probably have armies of lawyers who've left their simple country law office and gone to work for the man. And they'll just have this all written right up. But as I understand the bill, and this amendment operates through that bill, this bill an amendment also affect all the onesies and twosies, if you will, that those of us who are simple country lawyers occasionally have someone call us up and say, you know, I get this from time to time in my community. Hey, I was referred to you. I'm in the military. I'm going to be going wherever. I plan to settle back here. I don't want to sell my house because I'd never be able to afford another house here when I came back. So I'd like to rent it out. Could you do me a lease? Well, I'm going to know that we need to go find the new clauses that the Colorado Bar Association will inevitably put together, knock on wood, to comply with this. But for every one of those who calls me, there must be dozens of others who just are going to rent their house to an acquaintance or some. I can think of an instance not many years ago where someone I knew got some renters that were older college students, and they just drew up their own lease. They just went on Zoom or LegalZoom or whatever those things are. And they just got a standard lease. Well, the likelihood that they're not going to be in compliance with this is pretty high. And yet, that's an important part of the market. And the reason I'm concerned about this is, you know, if you look back at the bill and how it would apply, a landlord's an owner, manager, lessor, sublessor, successor in interest or agent or owner of a residential premises. So, you know, if you're one of those people, once we have those units on your back lot that the governor wants all of us to build on, you know, in your backyard, they want to build a tiny home back there that you lease out, you're going to find yourself with liabilities. In fact, if you come to my office or call me on the phone, I'm going to tell you, you ought to think hard. You ought to think hard about whether you want to get in that business or not. Because the big guys, they're going to have the resources to protect themselves, and they're going to have the resources to put someone up, and they're going to have another unit or something. My concern about the amendment, although I think the amendment is an improvement and I'm supportive of the amendment, my concern overall about these kinds of requirements that are added in the amendment, there are some good things there in the amendment as well, but added requirements just highlights these requirements and how they are going to discourage people in your district who have who own a duplex and live in one side and want to rent out the other. It will be an absolute discouragement to them. And I would probably, as a risk matter, tell them that if they don't have a lot of time and they're not willing to put me on their Rolodex, well, we don't have those anymore, but put me on me or someone like me on their speed dial. You don't want to do this. And I thought our goal in this session was to do something about affordable housing. So the amendment's an improvement, but not enough. Thank you.
Mr. Minority Leader. To L010, right? To the amendment?
To the amendment?
To the amendment?
Oh, I'm sorry.
The motion is the adoption of L010. All in favor say aye. Aye. Opposed, no. The ayes have it. L010 is adopted. To the bill, Mr. Minority Leader.
Thank you very much, Mr. President Pro Chair Tim. That's right. Mr. President Pro Chair Tim. A little bit of level setting and context setting as we dive into the broader conversation on Senate Bill 94 and some potential amendments to the bill. Want to acknowledge the challenge we face as lawmakers and policymakers. We frequently hear from the most extreme and most challenging circumstances, and of course they are extreme and challenging circumstances that we want to, in fact, address and deal with. But they aren't necessarily always an accurate representation of broadly what's happening in a specific sphere of our society. I think most landlords work diligently to make sure that their properties are habitable and attractive and, quite frankly, earning the most rent that the market for that particular type of dwelling would earn. And in order to do so, habitability is critically important. So we are confronted occasionally with bad landlords and potentially bad tenants, a situation where individuals are in conflict or in difficult circumstances and, quite frankly, not treating each other the way that we would all prefer everyone be treated. You know, the good old golden rule, do as you would be done by. That does not always happen. And so we then, when confronted with the circumstance of human breakage, start to write laws to address and control and fix that problem when it might, in fact, at the end of the day, when we finish the work product that we as legislators create, the policy we create, overreaches and it creates difficulties that intrude upon the broad sweep of positive interactions that are happening. In this case, intrudes upon the broad sweep of great landlords doing great work to provide affordable housing to the people of Colorado in a meaningful way. And so comes Senate Bill 94. As presented, the people that do apartment work in association gathered together considering how they do their business, they read the bill and they kind of threw their hands up and said, wow, we do not know where to begin. If we were to give our suggestions, which we do in the parlance of legislating, we would write a red line that looked like this. And that red line had probably more red lines than original black and white lines in this 42-page bill. That's how far it was from accessible, usable, beneficial in what we're all trying to work together to provide. And that, at the end of the day, on this particular circumstance, is affordable housing. Because we have a crisis of affordable housing in Colorado today. And so we write a bill that says, hey, I've got an idea. Well, actually, this isn't my idea. My idea is we've got problems, we need to fix the problems. But the net effect of a bill like 94 is to make housing in Colorado potentially less available and less affordable. And it's not because of the circumstances we hear, in all of us here in committee, difficult circumstances experienced by an individual. But when we write law to that specific circumstance, we frequently write law that does not benefit the broad sweep of the people of Colorado. In this case, the broad sweep of people renting their homes in Colorado and landlords providing the roofs over those people's lives. So then we engage, and kudos to the bill sponsors. The good senator from Denver is famous, in moments infamous, but famous generally for working to see the best policy outcomes we could possibly pursue. And I am grateful for Amendment 10 and the improvements that it brings to this particular piece of policy. But my perspective doesn't get us there. It's still missing some fundamental and critically important elements that we should be considering. And I have without much notice, and I apologize I didn't have more notice for the bill sponsor, but quite frankly, I didn't have much notice myself. This bill has been laid over a couple of days. We've been scurrying about for the last couple of days, trying to get the various individuals who we would call them stakeholders. I don't especially like that word. I think it's a riff on the idea of shareholder. You know what shareholder is? That's somebody who takes dollars, and dollars are a representation of their life, the hard-earned time that they may have spent, the sweat of their brow, the power of their mind to create value and therefore get dollars. Well, they take those dollars and they buy into a company and they have a share, a portion of the company. So there is meaningful relationship between a shareholder and the company which they participate in. Stakeholders can be people that just show up and say, look, I'm a gadfly, I want to talk about this, and I think my thoughts are this, and you ought to do that, and so they could be in that extreme. At the other end of the spectrum, there are people who are affected by the policies, either positively or negatively, and they have every appropriate reason to engage in the conversation. But this broad term we use, stakeholders, I'm not in love, if you would, with that word. So thank you, Mr. President Pro Chair Tim, for giving me a moment on that rabbit trail to talk about the language. The reality is the people who truly need to engage in this conversation, I would call them advocates and opponents, and they're the folks I always seek to listen to carefully. So, having said that, and I'll let the staff kind of divvy those up as they do.
There is an amendment of the desk. Will the clerk please read L007?
L007, amend the Local Government and Housing Committee report dated February 27, 2024, page 1, strike line 15, and substitute inception and tenant's occupancy 2.5, except as provided in subsection 9 of this section. A landlord does not breach the warranty of habitability if the uninhabitable condition at a residential premises is substantially caused by action, inaction, misconduct,
there we are,
or
Mr.
negligence.
Minority Leader.
Had to catch my breath, Mr. President, Pro Chair Tim. I move amendment L007.
To the amendment.
Ding, 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 ding. Got to do that when
Very
we
good.
have 007.
To the
Senate
amendment.
Bill 94.
To the amendment.
Thank you very much, Mr. President Pro Chair Tim. This particular amendment is written to the committee report. That, as a legislator, that's always the bane of my amendment existence. When they write an amendment to a committee report, and then I'm supposed to take that and figure out how to connect it to the bill, it's always a bit challenging. So let me do that for you. This particular amendment, 007, is modifying the committee report. And under the committee report, it goes to page 1, line 15, but let's skip right past that. I'm going to cut to the chase. This amendment actually goes to, we're all okay here in the front row? Popcorn. It goes straight to page 7, line 19, between line 18 and 19 of the bill, and it would insert some language. It says, except as provided in subsection 9 of this section, a landlord does not breach the warranty of habitability if the uninhabitable condition at a residential premises is substantially caused, not just on a whim, not just marginally, not just kind of maybe or sort of, but substantially caused by action, inaction, misconduct, or negligence of a tenant, a member of the tenant's household, a guest or invitee of the tenant, or a person under the tenant's direction or control. So you can look at these things: negligence, inaction, misconduct. Let's take misconduct. I'm going to fill the drain plug in my tub in my bathroom with silicone caulking and block that tub, and I'm going to turn the water spigot on, hot water and cold water, and just let it go. Next thing you know, bathroom's flooded, then the hallway outside the bathroom's flooded, then the bedroom down the hall is flooded, then the living room, everything ultimately gets flooded. Well, that was an extreme example, but again, when we talk about this thing, we've already addressed the fact that we tend to manage and write laws to the extreme example. That is an extreme example that might happen. I would hope it wouldn't, but it might. And at the end of the day, this amendment simply says, if that happens, it's not the landlord's fault. It's the tenant's fault. So it brings a little bit of real-world conversation and positive interaction and relationship between landlord and tenant to bear. It goes further if it's inaction or negligence by the tenant. I mean, this gets a little harder to discern, but let's say the tub's getting clogged with hair and it's draining slower and slower, and it gets to the point where it maybe isn't even really draining, but the water gets left on accidentally, and the next thing you know, that same set of circumstances I just described, tub floods, bathroom floods, hallway outside the bathroom floods, bedroom down the hall floods, living room, the whole apartment, next thing you know, or house has flooded. So this simply says, under those sets of circumstances, where the landlord was not culpable, was not even present, was not even aware necessarily, and wouldn't necessarily have had the means to be aware, they are not responsible. So I would urge the support of the James Bond Amendment 007 to Senate Bill 94, just based on the argument it's common sense. This is the sort of thing, as we're trying to take this bill that was, oh my gosh, I have no idea how to interact with this, and bring it back down to, okay, this is manageable, this is reasonable, this is the way we should interact in our policy development. This amendment moves us in that direction. I urge your support of Amendment L007.
Senator Gonzalez.
Thank you, Mr. Chair. I am grateful for the senator from Monument, the good leader, the monumental senators, recitation of his process to try to get to L007. We already know and already built in protections for the landlord that if the tenant is responsible for the problem, the landlord is not liable. You can see that we also added in addition to those protections, that we even added in additional layers that are referenced here within L007, that if the exemption to the misconduct is because the landlord is that the tenant is a victim of domestic violence, sexual assault, or stalking, that's the only misconduct that would not be protective for the landlord. So for that reason, I ask for a no vote on L007.
Any further discussion on L007? Seeing no further discussion on James Bond Amendment, the motion is the adoption of the All in favor say aye. Aye. Opposed, no. No. The noes have it, L007 is lost. To the bill, Mr. Minority Leader.
Thank you, Mr. President Pro Chair Tim. This next amendment I'm going to offer here is a little bit more wonky. The good country attorney with 2 law degrees from Texas might be the only person who truly understands it in its depth and detail. But let me argue it in the following way after I move it.
There is an amendment of the desk. Will clerk please read L005?
Amendment L005.
Mr. Minority Leader.
7.
Thank you very much, Mr. Chair. I move Amendment L005
to the amendment.
Senate Bill 94. Thank you. So this is around the language of rebuttable presumption. And this would eliminate the rebuttable presumption with the landlord. Cutting all the way to the chase, getting past all the legalese, boiling this down to the point where I actually kind of understand it, and I would encourage you might understand it as well. This really balances the scales. As drafted, the tenant has an enormous amount of power over the landlord in the process as designed by the bill, Senate Bill 94. Even when the landlord may be moving in good faith to resolve matters with every capacity they have within their control. If in fact they're doing that, we should in fact accept that as part of the conversation, and this particular amendment, eliminating the rebuttable presumption, would get at that. Now, I see the good senator from Colorado Springs with 2 law degrees is on his feet. I don't know whether he might be chafing at the bit to come and explain rebuttable presumption, but I'm assuming that might be why he's on his feet, and I will step from the well. Thank you, Mr. Chair.
Senator Gardner.
Thank you, Mr. Chair. Well, apparently there's a rebuttable presumption that if I stand on my feet, that perhaps I'm coming to the well, only rebutted by the clear and convincing evidence of my just standing there and not moving. Members, again, to speak to this amendment, one needs to speak to the bill. The bill has a provision and I need to find the beginning of this thing. And it starts, and this is what the amendment kind of removes, and this, I need to speak to this to let you understand why it's important. On page 7 of the bill, at line 19, what's subparagraph 3A says, there is a rebuttable presumption that a landlord has failed to commence remedial action, and that's what invokes liability if a landlord doesn't take remedial action. And on. Rebuttable presumption if. Now, what's a presumption in the law? What's a rebuttable presumption? Well, a presumption in the law, if it's just a presumption, if you show certain things to a court or to a jury, then it raises a presumption that is, without anything else, the fact finder can find that fact. There are things that are rebuttable presumptions. Most presumptions are presumed to be rebuttable. Now, what does that mean? That means that if you have certain things, then the fact finder is going to presume, is going to find that the landlord has failed to commence remedial action, which imposes pretty hefty liability here. So what are those things? If the landlord's failed to communicate with the tenant after having actual or constructive notice, I think we've cleaned that part up, of a condition within the time frame. The condition continues to exist. You got to keep reading here. It takes 2 law degrees to keep doing this. 14 calendar days after the landlord received received notice, let's just say, where the residential premises are uninhabitable. So if the landlord is having trouble for 2 weeks getting somebody to come out and fix this condition, that will create a rebuttable presumption. Now, the thing that lawyers always say is, well, if there's a rebuttable presumption, that is, some facts exist and the fact finder is going to find against me, but I can show them otherwise, then you always want to know, well, what would rebut the presumption? What would overcome the presumption? Well, the problem here is that the presumption may only be rebutted by establishing through clear and convincing evidence that the landlord commenced, et cetera, et cetera. Now, in the law, when you go to law school twice, they teach you that at common law, historically, there were two levels of proof. One was the criminal level of proof of guilt, finding guilt beyond a reasonable doubt. Has to be proved beyond a reasonable doubt. Now, there are whole long jury instructions about what beyond a reasonable doubt is. Reasonable doubt is not some remote doubt, it's reasonable doubt, but beyond any reasonable doubt. And then there's historically this civil standard of proof, which is preponderance of the evidence, which is what it takes to find you liable in an automobile accident, what it takes to find you liable for some sort of civil liability. That's the traditional thing. Well, then along came, in the 20th century, a different standard of proof. Now, you know, we got along for 400 years with proof beyond a reasonable doubt and preponderance of the evidence. And then people said, well, I want, in civil cases, and these rent cases are civil cases, I want some higher level of proof. And courts came up with the notion of clear and convincing evidence. That's evidence it's not proof beyond a reasonable doubt, but it's pretty high. Now, the problem with that is now we're going to allow a fairly straightforward presumption because of what a landlord does or doesn't do or sets of circumstances that exist. And we're going to say that will constitute evidence for a finding against you, landlord. But you can rebut that. Now, the first thing only has to be proved by the preponderance of the evidence. But you can only rebut that once it's there by a very high level of proof. I don't want to talk about the devil, but I am. The devil's in the details. And the details here are what it takes to rebut this standard. Now, the amendment is good because what it does is it just does away with the presumption altogether and allows the fact finder to simply find from the facts and circumstances whether or not the landlord has discharged its duty. Let's remove this presumption altogether so that we don't have this, what does it take to rebut? Because right now, you can create an easy presumption and a very, very difficult burden to rebut that presumption. This is so favorable that it incentivizes lawyers to go into this business. And I don't know if you want to incentivize lawyers. I don't think people want to incentivize me to come down here and talk. It seems like incentivizing me is not something you'd want to do. I really do urge your support for L005 because this structure is not going to make for more affordable housing in Colorado. It is going to force more and more people out of the business of providing housing by rent. Thank you.
Mr. Minority Leader.
Thank you very much, Mr. Chair. I step back into the well to renew my call for your support and I vote of Amendment number 5 to Senate Bill 94. The elimination of the rebuttable presumption. I think it's a good way to balance the scales appropriately, and all of these arguments I'm making are in pursuit of affordable housing for the people of Colorado.
Senator Gonzalez.
Thank you, Mr. Chair. I just first have to comment on the good senator from Monuments' characterization that somehow this bill gives incredible power to tenants and the pobrecito landlords. I just fundamentally don't understand that characterization. And I would encourage you all to just think about that comment as you are now considering L005. The intent of L005 would shift the power dynamic only in the context of things getting so bad enough that a tenant would have to go to court to ask for the court to intervene. What 94 seeks to do is to balance that power dynamic when things have gotten so bad that the tenant is left with no recourse but to go to court. And so for that reason, I ask for a no vote on 005.
Seeing no further discussion on L005. Seeing no further discussion on L005. All in favor say aye. Aye. Opposed, no. No. The noes have it. L005 is lost. Mr. Minority Leader.
Thank you, Mr. Chair. I have an additional amendment here that I would like to offer. This one gets into some of the nuances. Again, we're not going to litigate it too far, but want to, first of all, acknowledge gratitude again for Amendment 10, which has already been added to the bill.
And really quickly, before you move forward, there's an amendment of the desk. Will the clerk please read L004?
L004, amend printed bill, page 9, strike lines 18 through 27.
Mr. Minority
page
Leader.
10.
Thank you, Mr. Chair. I move Amendment L04.
To the amendment.
Would describe it as following. Actual notice is when the landlord is clearly notified. Constructive notice is this odd construct where it was on the landlord to have known. They should have known. They should have known. And that's just impossible. You can't, in that circumstance, know you're putting the landlords. And again, I guess in my earlier comments, I didn't intend to imply that the tenants were incredibly powerful. I was simply arguing that scales were closer to balanced. And that's, again, what this particular amendment would be about. Amendment 10, which has already been put into the bill, talks about written notice, which is beneficial. It still doesn't go as far as I'd like to go, and hence I urge your support of Amendment L004, which would clean up the actual notice, constructive notice, written notice elements of the bill.
Senator Gonzalez.
Thank you, Mr. Chair. And I appreciate the comments from the good senator from Monument about this, about the power dynamic, one, and then two, this amendment. Here are the outstanding types of constructive notice. Notice from a governmental entity, notice from a third party, notice from a tenant concerning a condition that may affect multiple tenants, and correspondence with maintenance staff or maintenance service provided by the landlord, that type of third party. Observations or reports that the landlord has obtained personally, directly, or indirectly. I believe that actually directly or indirectly was addressed in L10. But the reason that we included these other types of notice was to actually capture in Mr. Anderson's Mr. Anderson's situation, the fact that he reached out to a government agency, CDPHE, to come out and do an inspection. CDPHE gave the landlord the notice, and that should be sufficient. If I see in my ceiling all of a sudden a leak, I know it ain't coming from my unit. It might be something that is happening in the unit above me. That should also be sufficient. And so that's why I ask for a no on this amendment. Thank you for bringing forward the amendment, Senator, but I think given the fact that if it's not my unit, but I know that something's going on in the unit above me or next to me, if a hole punches through the wall, right? And it's not my unit, but it's something next to me or above me, or if a government agency comes forward, we want to make sure that those issues get addressed as well. Respectfully, I ask for no.
Mr. Minority Leader.
And I renew my call in support of Amendment 4. The reality is the circumstances and the cases and the fact pattern offered do seem commonsensically to provide access for the landlord, but not everything under constructive notice would be of that nature. So this amendment would clean it up further. I urge your support of Amendment L004.
Seeing no further discussion on L004, the motion is the adoption of L004. All those in favor say aye.
Aye.
Opposed, no. No. The noes have it. L004 is lost. There is an amendment at the desk. Would the clerk please read L012?
L012, amend printed bill. page
Mr.
12.
Minority Leader.
Thank you, Mr. Chair. I move Amendment 12 to Senate Bill 94.
To the amendment, Mr. Minority Leader.
All right, so part of what the bill says, if you've got a situation where somebody has to be moved to an alternate location, the landlord's responsible for providing that for up to 60 days. I contemplated capping that, bringing it down, making the timing narrow. I said, no, let's leave it at 60 days, but let's give especially an acknowledgement of the fact that this bill doesn't just sweep up the gigantic apartment complexes, it sweeps up all the mom and pop renters, landlords also. And for them to be responsible for somebody putting, and I'm going to use extreme examples because we're working with extreme fact patterns in this particular case. You have to put your tenant up at the Ritz-Carlton. In extreme example, I acknowledge right up front, hyperbole for the sake of making the point, you have to put somebody up at a place that may be substantially more expensive than what the rent that you are receiving for the apartment or the home that you have somebody in. This amendment simply says, look, get them in a commensurate lodging solution, and it shall be capped at the same cost as what the rent would be. It's just, again, this is a balancing the scales sort of amendment, and I'm thinking specifically of the mom and pop, the smaller landlords, and that they are swept up in this bill. Make no mistake. This isn't about big, bad apartment complexes. This is about your parents or your parents-in-laws who've finally put together enough money and they've got a rental property. They are now going to be subject to this sort of information. Let's not put them in a financial bind. Please, if you would, support Amendment L012.
Senator Gonzalez.
Thank you, Mr. Chair. And thank you, Senator, to the Minority Leader for his comments in regards to the, what is it, L12? Here's the issue. We actually had lots of discussion about this, both in committee and afterwards, that honestly, the vast majority of tenants don't even want to be put up in a motel or a hotel or anything like that. Certainly, let me tell you, if y'all can come up with one instance of a tenant being put up at the Ritz or even a Hilton, I'd love to hear it, because that's not what we're hearing. We actually also, to be clear, and joking aside, were intentional so that if we're talking about not a hotel or a motel, but an Airbnb, that we could have that flexibility. And I will remind the Minority Leader that the language of the bill, as it's already contemplated, only says that a hotel or a room would be provided at the tenant's request. In the overwhelming majority of these circumstances, the tenants, in my understanding, the overwhelming circumstances of these situations, the tenant says, you know what? Nope, I'm going to go stay at my mom's. I'm going to go stay at my cousin's. I'm going to go stay with a friend down the street. And so, respectfully, I ask for a no vote on L12.
Any discussion on L012? Seeing none, the motion is the adoption of L012. All in favor say aye. Aye. Opposed, no. The noes have it. L012 is lost. To the bill. Seeing no further, Mr. Minority Leader.
And so we come to the end of the discussion of most of the amendments. There is in the wind a rumor there might be another amendment, and I would at this point speak to the bill. Back to the entry point where I joined in. We need to be, colleagues, incredibly sensitive to the fact that housing is unattainable and housing is unaffordable for far too many people in Colorado today. We need to come together, work together, in fact, improve that circumstance. We have a couple other bills. One was considered last week or earlier this week with regard to construction defects litigation. I think that might, in fact, get us into the zone where we're starting to think about making housing more affordable. This coming week, we've got another bill of the same nature. But this particular bill is about the most affordable of housing. It's the housing that you can access without a down payment, with just maybe a couple of months' rent, a deposit of a month's rent perhaps, and your first month's rent probably due when you sign the lease. The ability to get into a place that you can call home. And this bill will, I believe, over time, like so many bills of this nature, which is intended to do good. It's intended to solve a problem for a tenant who had a really bad experience. But it will ultimately, I believe, drive up the costs, lower the accessibility of homes and places for people to live who depend on apartment homes or homes that are rented out by individuals for the place that they want to call home for they and their families. And so I'm deeply challenged, and ultimately, even though it's been amended to make it better, started out really bad. Now it's only kind of bad, but it's still kind of bad. And so I end up in this no position on this bill, even as amended, because I am convinced, I am convicted, it will make housing less affordable and ultimately less attainable for many people in Colorado. And I cannot allow that to advance as a matter of policy from the General Assembly without my objection. And so I object. I will be a no vote on Senate Bill 94 for the reasons mentioned and the absence of, quite frankly, a few amendments that, had they been put on, would have made it even a little bit less bad. But it's still, I don't think, the right policy for the people of Colorado. Mr. Chair, I appreciate your patience and support as we work through the machinations of running amendments today, and I will close as I began by calling you Mr. President Pro Chair Tim.
Excellent. Senator Gardner.
Thank you, Mr. Chair and members. I don't know how many times I've come to the well in the past several days and used the phrases well-intentioned and ill-considered. This is well-intentioned. We created some warranty of habitability several years ago when I was in the House, and we got as much fence around that as we could in terms of remedies. My concern is not with requiring a landlord to warrant habitability, and by that saying that the conditions that must be provided with the unit, the property, ought to meet some minimum standard. They ought to be habitable for the human being. By the way, what's habitable in certain parts of our state may not be habitable in other parts of our state. And I'm just talking about variations in climate and temperature extremes. But where this bill really goes wrong is in setting up the standards and the causes of action and the rights and remedies of the tenant. For instance, while the minority leader offered an amendment to limit the liability of a landlord if they had a problem, the boiler goes out. Now, I don't know if any of you have heard the busted boiler story. I call it that because you hear from time to time, particularly in our supply chain challenged world, you hear even large organizations being told by their heating, ventilation, and air conditioning people, commonly referred to as HVAC, you hear them being told, you've got a boiler problem and it is going to be a month before we get the parts to take care of your boiler. Well, can you go buy space heaters for everybody? I mean, that would be my proposed solution so that people don't freeze. But I don't know. You get a lot of questions about what's going to be adequate. And you know, if something becomes uninhabitable, I haven't gotten deeply enough into the bill to see if it becomes uninhabitable because it flooded or there was an earthquake, they happen, heaven forbid, but they do. Will the landlord have to provide that? Maybe the landlord's house got flooded too. Maybe it's a huge and natural disaster. I don't see a so-called force majeure provision in this bill that would say, you know, there are acts of God that knock everybody out. And that's not something we would expect landlords to have to deal with for their way. What if you're on Maui? I mean, we're not there, but that kind of natural disaster occurs in this state periodically. You know, what this bill does is require the landlord to become the insurer for the tenant. And not just, and by the way, insurers are very thoughtful about setting up the limits of their liability, but this bill doesn't set any limit on liability for landlords at all. It says they have to get you a hotel room. Well, comparable. Well, okay. But given what the circumstances may be, last time I looked, Airbnbs cost more than long-term rentals. I have one of the least expensive Airbnbs for my short-term rental that you can get around Capitol Hill here, and some of you have them, and they are more expensive than long-term rentals. So a landlord who's going to have to provide that is going to have the risk, accept the risk that something may happen, that the boiler may go out, the air conditioning system may go out in July. And what is that going to do? Well, it's going to put them out of business. And if they're not in business, what are they going to do at that point? Well, you know, the conclusion I reach about this bill, and if it passes here in Colorado, is, again, I alluded to this earlier, my standard advice to people is going to be, hey, the real estate market for sales is very, very high. It may be going, it may bust sometime soon, I don't know, but it's very high for the moment, and your rental risk is very, very high. What should I do? They say. Well, maybe you ought to sell that property and take your profits and put it in Bitcoin. Your risk wouldn't be any higher, I'm going to tell you that. And you'd have less headaches. But you could put it in, you could put it in good, strong mutual funds. You could do something like that. Here's the point. This bill could be entitled the Anti-Affordable Housing Act of 2024. It's well-intentioned, but the remedies and the way that they are implemented mean that particularly small renters, smaller landlords, the kind of people who come to see me and my law practice and say, I need a lease, what are my rights and obligations? I'm having trouble with the tenant. The air conditioning went out in the middle of July and I'm trying to get somebody to fix it, and my tenant says I have to put them up in a hotel room, and they want to stay at the Broadmoor. And I say, well, they probably don't get that, but it's the height of the tourist season, and we're going to put them up. So, members, this is not affordable housing. It's not adequate housing. It's the lack of housing. I urge you to vote no.
I'll be quick.
Mr. Minority Leader.
Mr. Chair, I just want to bring the dollars and cents of this down. The way the bill, as amended with 10, operates is if there is a breach of warrant of habitability, but which you've got 10 to 14 days to solve that. But the clock starts running immediately on a 60 days replacement. You've got to find alternate lodging. And so the only way for a landlord to begin to interact with this new marketplace as created by this bill is to add an additional 60 days of additional lodging into every lease. And so that is the exact fact of how it will increase the cost of housing. The most affordable housing, apartment housing, will be increased by virtue of this bill, by virtue of that one certain aspect. Add an extra 60 days of lodging into every lease. That's what landlords will be forced to do. Thank you, Mr. Chair.
Senator Mullica.
Thank you, Mr. Chair. So, members, I've been trying to read the bill since it came out, and I've had conversations with the sponsor about this bill, and in all honesty, the bill is a tough bill to follow, and and had a lot of questions. And credit to the good senator from Denver who helped walk me through some of it, because I think the terminology I used when I was speaking with her was that, you know, it made me dizzy sometimes in places trying to read it. You know, I think that I also want to give credit where credit's due as well to the sponsors. I think that we've seen a lot of changes and a lot of responses to, I think, some concerns that we've heard on this bill, and we've seen that happen through these amendments. You know, I still have some questions, and you know, and we can even maybe discuss those offline with the sponsors. But you know, specifically around if damage to the unit is caused by the tenant or a natural disaster, what does that look like, and whose responsibility is that? But I also wanted to take an opportunity, because I think, you know, we've heard the discussion today around rebuttable presumption. You know, and I'm a nurse, I'm not a lawyer, you know, and so you know, some of these terms you have to go search up. You know, I think there's a piece of me that's concerned with that language, just because, you know, I think my goal is to see that relationship between a landlord and a tenant. You know, my goal is to make sure that both are operating in the right fashion and both are living up to their end of a contract between the two of them. And I don't want to see that relationship necessarily start off on an adversarial step or kind of an aggressive step. You know, and I think that there hopefully are some conversations that we can have around that language while still trying to achieve that goal, and to achieve that goal of making sure that that line of communication is open, coming from both parties. You know, and I think we saw some of that communication being required in the amendments that have already been accepted. But I look forward to maybe trying to find some language to make sure that that there's other communication, and if there's a delay or a reason why a project's not being done, that communication's coming from the landlord to the tenant, so that we have that relationship, and that communication's being open from both sides. And potentially, if we can get there, that you know, we're not you know, having, you know, automatically starting off on an adversarial step between the two parties. You know, because I definitely agree with what the intent is, which is making sure that that communication is open, making sure that there is a level of accountability. You know, I think that you know, there is a job of the landlord to provide a habitable unit. Just like it's the tenant's, you know, responsibility to take care of the unit and to pay the rent on time. You know, and I think that relationship can be a good relationship in most cases. You know, and so I'm just really concerned that we don't allow that relationship to start off on the right foot with some of this language. And so, you know, I've talked to the sponsor offline. I look forward to maybe having some future conversations potentially later on, but I just wanted that to be known, and to also make sure that, you know, to give credit, like I said, where credit's due for the work that's already happened on this bill.
Senator Liston.
Thank you, Mr. President, Mr. Chairman. Members, I've been listening to the debate on this bill and can appreciate it sounds like there's been some movement, some compromises and amendments, but overall, like has been mentioned, the law of unintended consequences. Unfortunately, what's going to happen is, as was alluded to, if and when, unfortunately, probably when this bill passes, no matter how it's amended, is that it is going to devastate the rental market, especially for the smaller units, the mom and pop operators that have put their life savings into a building where they have a 1 or 2 or 3 or 4 units, you know, just a handful. It is going to drive up the very people that they're trying to help, the renters. A landlord is going to be forced, like has been said, to compensate for the potential liability of that if something happens. They are going to have to put up the tenant in a hotel or motel unit, where right now I can speak because just like my good colleague from Colorado Springs, Senator from Colorado Springs was talking about, I too have a short-term rental agreement. In fact, I just sent the landlord the next 60 days' rent, which I knew I had to do. And when she finds out her potential liability of what's facing her, she and her family, who are refugees from Vietnam, they've bought this unit or two, the unit that I live in. They put their life savings into fixing up the unit. It was greatly distressed 3-4 years ago when they bought it. They've fixed it up. They've furnished it. They're doing all the right things. And when they find out the potential and the probable liability that they're going to have, she, through no fault of her own, that suddenly what she's charging me at roughly, let's call it $90 a day, plus or minus a little bit, that potentially she's going to have to put me up if something drastic happens in a comparable hotel unit at a minimum of $150 to $200 a day. She's going to be forced to raise her damage deposit by a significant amount, and that's going to price people out of the rental market. You know, right now, a damage deposit can be $1,500 or more for a reasonable apartment. So that's going to go to $2,000 or $2,500. The other thing that's going to happen is that for those property owners that already own a unit, they're going to, because they're aware of this and other anti-real estate, anti-landlord pieces of legislation, they're going to say, I'm out of here. And they're going to start putting their properties on the market, and there's going to be a flood of sale. There's going to be more and more real estate on the market, and prices are going to go down. In some places, they may even actually crater. And just the idea of property rights, that the people who have put their life savings and are doing things right. Yes, there's always, unfortunately, a bad operator or two, but the vast, vast majority of people that I know that are in the that own a unit or two or three or four, they want to do the right thing. They value and want to keep good tenants in there, and it's a high-risk business as it is, anyways. So no matter how well intended something like this is, it is going to have the adverse effect of raising certainly damage deposits, probably raising rents, and at the same time probably depressing the price of real estate. The large operators will be able to handle it because they have the sophisticated staffs and the expertise and the financial resources that they can probably weather the storm. But it's unfortunate that that our state and our country has turned so negative against property rights. You know, if this was so easy, then why doesn't everybody get into it? Right now, as it was alluded to, right now the risk-free rate of return is about 4%. They could sell their property for $500,000 or whatever easily. That's low. $500,000, $1 million, and put it in Treasury bills and Treasury notes and have a risk-free rate of return of at least 4, if not 4.5%. Easy peasy. They could put it in certificates of deposit and get 4.5 to 5%. And that's what a lot of people are going to do. And the very people that this bill is trying to supposedly help are going to be hurt the most. So with all due respect, I would urge my colleagues to be a no vote on Senate Bill 94. I too will be a no vote. And I'm very sorry that the people that are out there that have tried to do the right things year in and year out, year after year, are now being hammered and hurt by this piece of legislation. I respectfully ask for a no vote on Senate Bill 94. Thank you.
Senator Janot.
Thank you, Mr. Chair. Okay, just want to get it right. Thank you, Mr. Chair. I rise in opposition to Senate Bill 94. And I really want to say that I know that the sponsors are trying to make this better in regards to safe housing for residential tenants. But what I've been hearing in testimony and in presenting this bill, and the good senator from Denver said the vast majority of landlords and tenants do right. Vast majority of tenants and landlords do right. They do. They want to make sure they keep their tenants. They have good tenants and that tenants respect their property and that they get along for the majority. I agree with the good senator from Denver in regards to the elevator issues. And I've even been called by people here in Denver about elevators not working and things of that nature. But I think, why are we looking at one example, maybe two examples, and why, if 98%, let's just say I'm taking a guess, why, if 98% of the landlords and the tenants are doing the right thing, are trying to make sure that their tenants are taken care of, why are we paying that price, 98% of us paying that price for 2%? It doesn't make sense. Why are we focusing on the 2%? If this is updating what's already in statute, 45 pages of this bill is not a classification as stated in the bill summary. It's a clarification of what's needed that could be done, not all these pages, but in 2 pages, especially by what I've been hearing the prime sponsors discuss. The other 43 pages, they're hard pro-tenant agenda, making the bill unpalatable. So landlords had no input, and this is what I've been hearing. I've been hearing it from northern Colorado in the Springs, on the western slope. They came to me to tell me that they really did not have a seat at the table. One thing they wanted to make sure that that was stressed was not all realtors, because that was a deal that was brokered with the prime sponsors in regards to the realtors. But not all realtors are landlords, and they don't understand the bill. A lot of these smaller landlords do not understand the bill and how it represents their interest. The small landlords are, 35% of the rental market? And at this pace, and because of last year's landlord-tenant bills, that number is shrinking, and it's not to the advantage of the tenants. I stand here in opposition to Senate Bill 94 because I do believe that it goes a bit too far, and if those initial concerns by the prime sponsors are addressed, it didn't have to be in 45 pages. It could have been done in a couple of pages, and for that I will be a no vote, and I hope you are in opposition as well.
Senator Rich.
Thank you, Mr. Chair, and I'm up here to commend the sponsors for trying to make this a better bill. I sat in committee the other day, and I listened to all of the people that came to testify. I've listened to all of the comments today. And while I appreciate that this has become a better bill, I just wonder why it had to become a better bill why it wasn't a good bill to begin with. Because if you have everybody at the table, and maybe I'm naive in this, but when I came here as a legislator, because I used to work for legislators that always talked about how you do your best work when you work together. And so I'm looking at this bill and I'm thinking, this could have been a really good bill. And I also thought I could come to the legislature and do no harm. This does a lot of harm. And every time we get one of these tenant right bills, it does a lot of harm. I have many friends who aren't corporate landlords, but they are now selling their properties and they are investing in another state, not in the state of Colorado. So I don't know how this helps, although the way this is written, I feel like it's a tenant's wish list, and I feel like when all is said and done, it's going to be the tenant's attorneys who win the day. And I'm sorry it had to be this way, because this could have been a really good bill if everybody would have had a seat at the table. I'm urging a no vote.
Seeing no further discussion, the motion is the adoption of Senate Bill 94. All those in favor say aye. Aye. Opposed, no. The ayes have it. 94 is adopted. Mr. Majority Leader.
Thank you, Mr. Chair. I move the committee rise and report.
Motion for the committee to rise and report. All those in favor say aye. Opposed, no. The ayes have it. Committee will rise and report. Hey. Can you serve as the chair and I'll serve as president so we can keep it moving? Yeah. Oh, he's back. Come on, man. Come on. You trying to replace him? No, I'm trying to get you up here. Come on, bro. For real. It's Friday. Come on.
Senate will come to order. Senator Coleman.
Thank you, Mr. President. The committee has met and had a number of bills in consideration. Will the clerk please read the report?
March 8, 2024. Mr. President, your committee of the whole begs leave to report has had under consideration the following attached bills, being the second reading thereof, and makes the following recommendations thereon. SB 94 is amended, passed on second reading, and ordered engrossed and placed on the calendar for third reading and final passage. SCR 1 laid over until March 12, 2024, and retaining its place on the calendar.
Senator Coleman.
Thank you, Mr. President. Move for the adoption of the report.
The motion is the adoption of the committee of the whole report. Are there any no votes? Senators Van Winkle, Will, Gardner, Baisley, Minority Leader Lundin, Smallwood, Rich, Liston, Simpson. With a vote of 26 ayes, 9 noes, 0 absent, 0 excused, committee of the whole report is adopted. Senate Bill 94 is amended, passed in second reading, order engrossed, and placed on the calendar for third reading and final passage. Senate Concurrent Resolution 1 laid over until March 12th and retaining its place on the calendar. Mr. Majority Leader. Consideration of governor's appointments, consent calendar. Will the clerk please read all of the appointments listed on the consent calendar?
Members of the Board of Assessment Appeals effective July 1, 2023 for terms expiring June 30, 2024. Monty Mullins of Alamosa, Colorado, reappointed. John DeRungs of Denver, Colorado, reappointed. Claudia Crane of Crestone, Colorado, reappointed. Diane DeVries of Wheat Ridge, Colorado, reappointed. Jess Ketchum of Pagosa Springs, Colorado, reappointed. Effective July 1, 2023 for a term expiring June 30, 2027. Sandra Mercier of Westminster, Colorado, reappointed. For a term expiring June 30, 2024. Jeb Marsh of Dillon, Colorado, appointed. Members of the Advisory Committee on Governmental Accounting for terms expiring May 18, 2027. Carrie Bartow of Colorado Springs, Colorado, to serve as a representative of Special Service Districts, reappointed. Brenda Ritchie of Boulder, Colorado, to serve as a representative of City and County Governments, reappointed. Executive Director of the Department of Revenue for a term expiring at the pleasure of the Governor, Heidi Humphreys of Evergreen, Colorado, appointed.
Mr. Majority Leader.
Thank you, Mr. President. I move for all the confirmations listed on the consideration of governor's appointments consent calendar. That entails Monte Mullins of Alamosa, John DeRungs of Denver, Claudia Crane of Crestone, Diane DeVries of Wheat Ridge, Jess Ketchum of Pagosa Springs, Sandra Mercier of Westminster, Jeb Marsh of Dillon for the Board of Assessment Appeals, Carrie Bartow of Colorado Springs, Brenda Ritchie of Boulder for the Advisory Committee on Governmental Accounting, Heidi Humphreys of Evergreen for the Department of Revenue.
Is there any discussion? The motion is the confirmation of all of the appointments on the consent calendar. Are there any no votes? With 35 ayes, 0 no, 0 absent, 0 excused, the appointments are confirmed. Mr. Majority Leader.
Thank you, Mr. President. I move to lay over the consideration of government appointments Parks and Wildlife Commission to Tuesday, March the 12th.
You have heard the motion. All those in favor say aye. Opposed, no. The ayes have it, and those appointments will be laid over until March 12th. Committee reports.
March 8, 2024, Committee on Appropriations. After consideration on the merits, the committee recommends the following. Senate Bill 104 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation. Senate Bill 70 be amended as follows. Be referred to the Committee of the Whole with favorable recommendation, with a recommendation that it be placed on the consent calendar. Senate Bill 65 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation. Senate Bill 44 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation. Senate Bill 26 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation. House Bill 1347 be referred to the Committee of the Whole with favorable recommendation. Senate Bill 1 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation. Senate Bill 3 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation. Senate Bill 14 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation. Senate Bill 16 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation, and with a recommendation that it be placed on the consent calendar. Senate Bill 19 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation. Senate Bill 20 be referred to the Committee of the Whole with favorable recommendation. Committee on Health and Human Services, after consideration on the merits, the committee recommends the following. Senate Bill 125 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation, and with a recommendation that it be placed on the consent calendar.
Message from the House.
March 8, 2024, the House has adopted and returns herewith Senate Joint Memorial 1.
Announcements. Mr. Majority Leader.
Thank you, Mr. President. I move that the Senate adjourn until 10 a.m. Monday, March 11, 2024. Have a good weekend, everybody.
You have heard the motion. All those in favor say aye. Opposed, no. The ayes have it, and the Senate will adjourn until 10 a.m. on Monday, March 11th.